Vanakkam friends, Dr. Vanangamudi, formerly Dean Agriculture of Tamil Nadu Agriculture University, welcomes all of you for this presentation on intellectual property rights on behalf of Trinity Cultural Academy, Coimbatore and New India Publication Agency, New Delhi. And this is a 17th series in plant breeding and genetics. And this presentation will be more useful for all the graduates, not only agriculture graduates, all the professional graduates, engineering, medical, and the arts and science graduates. And now the intellectual property rights, what it means. It is a legal field that refers to creations of mind such as musical literacy, artistic work, inventions, symbols, names, images, and designs used in commerce, including copyright, trademark, patents, and related rights. Under IPR law, the holders of one of these abstract properties have certain exclusive rights to the creative work, commercial symbols, or inventions. IP is divided into two basic groups. The first one is copyrights and second one is industrial property. And let us now discuss on copyright. It is automatically assigns the exclusive right to the creative owner of literacy, all performing art like dramatic, music, artistic work, paintings, photographs, sculptures, advertisements, maps, technical drawings, cinematography, film, photography, sound and video recording, broadcast and telecast, phonograms, and in a computer program to reproduce the work, to issue copies, or perform or communicated in public, make any translation or an adoption of the work, offer on sale or rental, and to authorize others for doing so. This is the copyright. Next, we will see the industrial property that includes patent, trademark, industrial designs, trade secrets, and geographical indications. Among these, patent assumes highest importance. Earliest industrial property was enacted in Europe, that is followed by US Patent Act in 1793. In 1883, 11 Western countries joined together to establish the Paris Convention of the Protection of Industrial Property to harmonize the IPR law and practices across the member countries. At present, there are about 169 countries or the members, and pre-colonial India had an IPR regime that is practiced by Britain. India is the signatory of TRIPS agreement, hence it modified its patent law in conformity with the TRIPS agreement. Should also consider the use of information communication technology, that is ICT technology, for effective enforcement of the intellectual property rights in India. More initiatives on the lines of ICT help desk must be undertaken so the contemporary international standards can be adopted in India too. Now the TRIPS covers seven things. One is copyright and related rights, trademarks, geographical indications, industrial designs, patents, layout designs of integrated circuits, protection of undisclosed information, and all these are being covered under TRIPS. And IPR give creators exclusive right to their creations, thereby providing an incentive for the author or inventor to develop and share the information rather than keep it secret. Legal protections are granted by the intellectual property laws, which are credited with significant contribution towards economic growth. Economists estimate that two-thirds of the value of large business in the US can be traced in intangible assets. Likewise, industries which rely on intellectual property protections are estimated to produce 72% more value per added employee than non-intellectual property industries. Industrial IP is a strong tool for building and sustaining competitive advantage in the contemporary knowledge economy. Both domestic and international competition is boosted by the scientific and technological process in the sustainable manner by utilizing IPRs. There is a direct rationale for providing healthy and global system for protection of IPR due to the role in wealth creation. Moreover, the technology, investment, trade, which are key drivers of economic growth, which are embedded in IPR protection. Indian Intellectual Property Office is dedicated to mobilize the use of intellectual property for economic and social development by creating an IPR culture and enhancing knowledge and competencies in synchronizing with the global environment. Orthodox or conventional IPRs. The next thing, these are the conventional IPRs used by an individuals, companies, association of persons. It is segregated in different types like copyright, patent, and trademark. First thing is copyright. It is an expression and manner of expression. It protects the original literacy works like books, novels, lyrics, movies, songs, paintings, photographs, computer programs, etc. It gives the holder the exclusive rights to control reproduction or adaptation to such works for a certain period of time, maybe 10 to 30 years, depending upon jurisdiction, but more recently, life of the author or plus several decades. And the next one is patents. Patents is a right exclusively used for ideas, but it is of commercial use. Patents are generally three types: novelty, non-obviousness, and novel art. A patent is the right of an individual or a company or an organization to gain profit from the particular invention or unique manufacturing process. A patent is also an intellectual property relating to scientific and technological inventions. It is granted by the government of the country to the applicant and gives the inventor right for limited period to prevent others from using that invention in any form without permission. A patent can be transacted, purchased, sold, or even mortgaged. Patent law protects inventions. It gives the patent holder a right to prevent others from participating and practicing in the inventions without license from the inventor for a certain period of time. Patents can protect functional features of process, machines, manufactured item, asexually reproduced plant, composition of matter. Main amendments to Indian Patent Acts are no new chemical entity will be treated as patent, as they must pass the test of complete patent and registration in any other member country which is applicable to all the members of WTO. And trademark, the next one, the association of traders name with commodity traded gives rise to trademark. A trademark is a distinctive design which is used to distinguish the products or services of different business. Trademark, trademark law protects words, phrases, logos, symbols, sound, or even smell or combinations used to distinguish one product from another, which gives a distinct identity to a good. In circumstances where a competitor uses the protected trademark can go to court and obtain an injunction to stop the use. Trade secret protection helps to protect the secrets of the product or work. All due to globalization, the whole world has become a single platform, so do these gained importance. They include industrial design, geographical indications, plant varieties, and semiconductor layout designs. Out of these four, the semiconductor layout design is more vulnerable to copying, and the law was brought in the reference to agreements of TRIPS. A design is the presentation of a product resulting from features of color, size, shape, texture, or materials of a product or packaging. An industrial design rights to protect the form of appearance, style, or design of an industrial object. For an example, spare parts, furniture, textiles. And now the fourth one is cyber law. This term is used to describe the legal issues related to use of communication technology, particularly cyberface, that is the internet. It is an interaction of many legal fields, including intellectual property, privacy, freedom of expression, and jurisdiction. In essence, cyber laws are designated for the physical world to human activity on the internet. And fifth one is the geographical indications of goods. In recent years, Indian government has become aware of this importance of geographical indication following the debacles related to basmati and turmeric. And geographical indication is a notice of a definite product that have been produced in a particular place. Producer can use this sign only for the products from the specified region. So the geographical indication is not an individual property for use by the geographical indication of that region, which any producer may use. And the last aspect is the organizations involved in IPR. In India, the Ministry of Commerce and Industry, Ministry of Human Resource Development, Ministry of Information and Broadcasting, the Confederation of Indian Industries, Federation of Indian Chambers of Commerce and Industries, Associated Chambers of Commerce and Industries, and information forecasting and assessment council of Department of Science and Technology, the World Intellectual Property Organization of United Nations. It is located in Geneva, which is the apex intergovernmental body dealing with IPRs. With this, I am closing my presentation. Thank you very much for listening. Kindly watch this video, like, share, and comment, and subscribe the YouTube channel. Thank you.